afternoon.
Good afternoon, Your Honor.
Please be seated. All right, this is Superior Court Judge Thomas Daniel McCluskey. Today is Tuesday, July 7th, 2026. We're now on the record in the matter of New Brunswick Board of Education versus New Brunswick Today, which is docket number MID-C-85-26. And I have the appearances of counsel for the record, please.
Good afternoon, Your Honor. Robert Mahoney and my colleague Kimberly Brunner of Norris McLaughlin on behalf of the plaintiff, New Brunswick Board of Education.
Good afternoon, Your Honor. Bruce Rosen and Iris Bromberg on behalf of New Brunswick Today.
Okay, good afternoon to you all. And welcome to everyone who is here. All right, this matter has come before the court on the scheduled return date of the court's order to show cause with temporary restraints that was entered back on May 29th, 2026, together with the companion order to show cause that was entered on June 9th, 2026, pursuant to the Uniform Public Expression Protection Act, both of which applications have been made returnable for hearing today. Given the significance of the issues raised in these applications before the court, I thought it important, before I hear from counsel on the applications, to give context to how it is that we arrived here today and procedurally where things stand for the purposes of today. Now, this matter came before the court on an emergent application that was filed by the plaintiff, New Brunswick Board of Education, on late Friday afternoon of May 29th, 2026, seeking the entry of an order to show cause for preliminary injunctive relief with temporary restraints with respect to video footage that it had discovered had been posted on the YouTube website and channel of the defendant, New Brunswick Today, which speaks for itself, but generally speaking, depicted the apprehension of a student who had set off metal detectors at the entrance to the school and who was thereafter frisked and detained because a weapon had been uncovered on his person. Now, that application was made by way of counsel appearing remotely via Zoom, although I was in my actual courtroom. It was late Friday afternoon. And in light of the issues that had raised, the court had issued and entered its order to show cause on that date, and in which the court set today down as the return date of the order to show cause, compelling the defendant, New Brunswick Today, to show cause here today why and if a preliminary injunction should not be issued for the relief sought in the verified complaint. Pending today's return date, my order of May 29th that I did enter late that afternoon provided for an order compelling New Brunswick Today to immediately remove all confidential school security and surveillance video that had been taken at New Brunswick High School, which is within the jurisdiction of the New Brunswick Board of Education, as was posted on the website of New Brunswick Today, and further temporarily restrained and enjoined New Brunswick Today from writing or posting about the content of the confidential video footage of what turned out to be a 16-year-old juvenile student specifically at issue in this matter, and secondly, making any further postings of confidential security slash surveillance video as taken at any of the schools in the plaintiff's district. And those were referred to as the temporary restraints. And the order provided that the defendant would have leave to move to dissolve or modify those temporary restraints on 3 business days' notice to the plaintiff and plaintiff's counsel. Now, once what I have just recited was placed on the record, counsel for the defendant, Mr. Rosen, had made an oral request to the court for a stay of that order pending an attendant emergent application that he intended to make to the appellate division, which this court orally denied and subsequently memorialized its denial by an order the court entered on June 1st of 2026. Now, on June 1st, 2026, with that order denying the stay, the defendant, New Brunswick Today, then filed an application with the appellate division for permission to file an emergent motion for leave to appeal, coupled with a request for a stay of the court's May 29th order and the temporary restraints. And by order of the Honorable Lisa A. Puglisi, a judge of the appellate division, entered on June 1st, the defendant's motion for stay of the temporary restraints was denied. But permission was granted to the defendant to file a motion for leave to appeal on short notice, which aspect of the application was granted. The next day, on June 2nd, 2026, the defendant filed an application with the Supreme Court of New Jersey seeking permission to file an emergent motion and related request for temporary stay and other relief pending disposition of an emergent motion, which application was denied by an order entered by the Supreme Court, namely Justice Ann M. Patterson on June 2nd, 2026, and in her denial, Justice Patterson stated that, quote, the applicant has failed to make a preliminary showing of an entitlement to emergent relief. The appellate division already has entered expedited briefing on the appellant's emergent motion, close quote. On June 9th, 2026, 7 days later, after submittal and consideration of the defendant's emergent motion for leave to appeal, on June 5th, 2026, the appellate division, via an order entered by the Honorable Lisa A. Puglisi, the judge of the appellate division, and received by this court at 1:30 that day, denied the defendant's motion. And Judge Puglisi in the appellate division in that order stated, quote, defendant's motion for leave to appeal the May 29, 2026 order to show cause for preliminary injunction with temporary restraints is denied without prejudice. The order permits defendant to move to dissolve or modify the temporary restraints on 3 business days' notice to plaintiff, which would provide the trial court the benefit of the party's briefing of the constitutional issues raised in this matter, which it did not have when it entered the May 29 order to show cause. This would allow the trial court to address these issues in the first instance. Should defendant move to dissolve or modify the restraints, the trial court shall expeditiously hear the motion, close quote. Now, subsequently, the defendant, New Brunswick Today, nevertheless proceeded with filing its own application for an order to show cause pursuant to Rule 4:52 under the Uniform Public Expression Protection Act, which is reported at NJSA 2A:53A-51, seeking a stay of the action and for relief and remedy under that act, including a declaration that the plaintiff had failed to state a prima facie case or cause of action in its original verified complaint, and an award of a reasonable attorney's fees and costs for having the defendant take this action. Now, in that this court was on vacation then, the matter was nevertheless handled by the vicinage assignment judge, Michael A. Toto, after I was contacted on vacation, who then entered an order to show cause pursuant to the Uniform Public Expression Protection Act on June 9th, 2026, setting the matter of that application down for hearing in conjunction with the then pending return date of the court's May 29th order to show cause, and calibrated the required briefing to coincide with that provided for in the original order of May 29th. The next day, on June 10th, 2026. In light of that filing, the defendant then moved in this court seeking to dissolve the temporary restraints and to have a hearing on that application on June 15th, the next available date given the intervening weekend, and required 3 business days' notice. Now, having to be contacted on vacation, this court instructed Chambers to advise counsel that the hearing on the dissolution application would not be heard on June 15, as mistakenly demanded, and rather on the original July 7th return date on now both orders to show cause, and as the most expeditious date. It could be heard in coordination with the pending application given the court's calendar and with no exceptions. Undeterred, the defendant then proceeded with yet another emergent application to the appellate division for leave to file an emergent motion on short notice to be heard on the court's scheduling of the motion to dissolve the restraints. And by order of the Honorable Lisa A. Puglisi, Judge of the Appellate Division, entered on June 12th, 2026, the defendant's motion for leave was denied by the Appellate Division, and for the following reasons. And I'm quoting from Judge Puglisi's order. Quote, during the May 29, 2026 hearing on the order to show cause, the judge set the initial return date as June 29, 2026. However, defense counsel advised he was unavailable because he had a vacation planned for June 26th to July 5th. The judge granted the request for an adjournment to July 7, 2026. After we denied defendant's application for leave to file an emergent appeal, defendant moved to dissolve restraints on June 10th, 2026. The next morning, the judge's chambers sent an email acknowledging receipt of the application and advising the motion would be heard on the return date of the order to show cause, along with the original order to show cause and a second order to show cause filed by the defendants. The email further emphasized there would be no exceptions. And continuing, quoting Judge Puglisi, although not provided to us, defense counsel emailed a follow-up letter to the judge that afternoon. The judge's chambers sent an email indicating, quote, receipt acknowledged, and the request is denied. The court is currently on vacation, and the July 7th date already scheduled is as expeditious as this court can hear that motion in all related matters given its congested calendar and the other matters of emergent priority, close quote. Now, continuing Judge Puglisi's opinion. Defendant now seeks emergent relief, contending the judge is not following our June 9, 2026 order, that the, quote, trial court shall expeditiously hear the motion, close quote. Defendant contends it continues to experience irreparable harm each day. It seeks either a hearing on June 15, 2026, or a ruling staying the restraints imposed in the May 29, 2026 order. We decline to order the judge to conduct the hearing on a particular date for 2 reasons. First, defense counsel misreads the provision in the May 29, 2026 order permitting defendant to move to dissolve or modify the temporary restraints on 3 business days' notice to plaintiff and plaintiff's counsel. Contrary to defendant's contention, this provision does not require the court to hear the application in 3 business days, only that plaintiff must have 3 business days' notice of it. Second, the judge was cognizant of our order to, quote, expeditiously hear, close quote, defendant's application, and advised the July 7 return date was as soon as he was able to calendar. A trial court exercises broad discretion in controlling its calendar, and any challenge to that authority is, quote, reviewed under a deferential standard, close quote. And I'll omit the citations. And she continues, quote, calendars must be controlled by the court, not unilaterally by counsel, if civil cases are to be processed in an orderly and expeditious manner, close quote. And again, omitting the citation. We denied defendant's alternative request to stay the restraints imposed in the May 29, 2026 order for the same reasons we previously articulated in our June 9, 2026 order. Nevertheless, should the judge's calendar adjust such that an earlier date may be accommodated by both counsel, the matter should be rescheduled accordingly, close quote. That was Judge Puglisi's order. On June 12, 2026, the defendant filed another application with the Supreme Court, seeking permission to file an emergent motion and related request for temporary stay of the appellate division's denial order and other relief pending disposition of an emergent motion, which application was denied, again, by an order entered by Supreme Court Justice Ann M. Patterson on June 13, 2026. In her denial, Justice Patterson stated that, quote, the application for emergent relief is denied for the reasons stated in the appellate division's disposition dated June 12, 2026. So, that's a mouthful. But consequently, the matter of the court's original May 29 order to show cause and the ensuing June 9 order to show cause and the defendant's intervening and intertwined motion for dissolution of the temporary restraints has now come before the court for this hearing and oral argument on this day, July 7, 2026. Now, I have since had the opportunity to read and review all of the filings that have been made in this case, including being copied on the briefs that the defendant had filed in the appellate division and the Supreme Court, and including a submission that was posted as of yesterday by defense counsel, which the court has considered. And with that said, let me turn first to Mr. Mahoney, and we'll deal with the order to show cause of May 29.
Thank you, Your Honor. Your Honor, given that recitation of the procedural history of this matter and realizing, as Your Honor just said, that you have reviewed all the papers, the voluminous papers that have been filed in this action, I'd like to direct my argument to respond to those arguments that were made in Mr. Rosen's reply brief on his order to show cause, or the defendant's order to show cause, and his motion to dissolve the restraints, if I may. Judge, I think there's a fundamental misunderstanding. I think that the defendant has conveniently misconstrued exactly the relief that we're seeking in this court. Mr. Rosen states in his brief, quote, "There is no exception for juvenile proceedings in UPEPA," close quote. He says that on page 1 of his reply brief, Your Honor. There doesn't have to be, Your Honor. The legislative history of UPEPA makes it absolutely clear that UPEPA is a procedural statute. It gives a defendant the opportunity to come into court upon the filing of a complaint and argue that complaint is a strategic lawsuit against public participation, the so-called anti-SLAPP statute. It does not create rights other than procedural rights. It does not make more broad than was before what is and what is not a matter of public concern. In fact, the legislative history of UPEPA makes it absolutely clear that what is and is not a matter of public concern is to be determined by pre-existing case law and statutory law, Your Honor. And in this case, Your Honor, we have argued in our original application in opposition to the defendant's motions, we've said exactly this. How is the identity of this juvenile student, a 16-year-old, how is that identity a matter of public concern? They refuse to answer that question, Your Honor. They say that the board, in fact, is acting as an editor. Mr. Rosen says in his brief that the board would like to act as an editor and decide what can and cannot be published. Well, the board's not acting as an editor, Your Honor. The law acts as an editor. The statutes that we cite and discussed at length in both sides' briefs, the UPEPA, of course, the Federal Educational Rights and Privacy Act, so-called FERPA, the New Jersey Pupil Records Act, the statute which governs the confidentiality of proceedings in juvenile court. All of those statutes make it absolutely clear that student records are confidential. The board has a duty under FERPA and under the New Jersey Pupil Records Act to maintain the confidentiality of the student records. The board has an obligation in its standing in loco parentis to stand in the shoes of the parents of this student to protect that student's identity and protect the public records, Your Honor. So the board is not acting as an editor. The law acts as an editor, and the law tells us what is and what is not a matter of public concern. And the law is crystal clear on this, Your Honor, that the identity of this student is not a matter of public concern. The defendants have never made an argument as to why it should be. Turning, Your Honor, to the second reason why we've asked for the temporary restraints and now the preliminary injunction in this case. Non-disclosure of the video, which would show the security apparatus, the security environment of the New Brunswick Public Schools, specifically in the high school, Your Honor. It is absolutely clear in this day and age, Your Honor, that school boards have a duty to protect the safety of the students in their care. We can think of the numerous school shootings incidences which have occurred across this nation in the last several years. metal detectors, screeners, location of cameras, all of that, Your Honor, is highly confidential to the school board. And that confidentiality must be maintained so that the safety of the students is maintained. Now, Mr. Rosen makes an argument in his brief that anyone who comes into the school can see where the cameras are located and can see where the metal detectors are located, Your Honor. But that's not the point. The people who come into the school are invitees. The people who come into the school are the students and the staff. Our concern is with people who are not students, people who are not staff, who will see the security apparatus in advance, and these wrong actors could do great harm to the students that are in the school board's custody at that time. Mr. Rosen's argument is the same argument that he made in the New Jersey Supreme Court case of Gillian versus Township of Bloomfield, where that's the case, Your Honor, that deals with the security camera outside the township building, showing the parking lot and showing the entrance. Mr. Rosen argued in that case that the camera's there. Everybody can see that there's a camera, so why can't we see the footage of what it's recording? It's recording a public space. Well, the Supreme Court said, yeah, everybody knows that the camera's there, but the scope of the camera's surveillance area, the width, the depth, the clarity of the images, as well as when it operates, whether it operates intermittently, and if so, at what intervals, and at what intervals it does operate. That's the information that in the Supreme Court case in Gillian that the township wanted to protect and that the Supreme Court protected, and that's the information that the school board, New Brunswick Board of Education, wants to protect in this case. The location of the cameras, how they operate, the width that they capture, the scope, the clarity of this capture. All of that, Your Honor, is terribly important to maintain the security of this school. So, Your Honor, because the defendant has failed to describe why the identity of this student is a matter of public concern, the defendant is free. Let me put it this way, Your Honor. The plaintiff, the Board of Education, never asked this court to prevent the defendant from writing or reporting about this incident. The defendant has. The pleadings in this case are public record. Other media has picked up the story. So there's we have never sought a prohibition against them reporting on this incident. What we have sought, Your Honor, is a temporary restraining order and a preliminary injunction from using that video which would depict the identity of that student and which would disclose the security apparatus in the high school, Your Honor. Neither of those things are a matter of public concern, and because they're not a matter of public concern, step one under the UPEPA statute has not been met. And we don't even need to get to step two as to whether our complaint states a cause of action, because step one, if there's a failure to establish a matter of public concern, the UPEPA analysis is over. So we respectfully submit, Your Honor, on the basis of the fact that the identity of this student and the visual depiction of the security apparatus in the school are not a matter of public concern, that under UPEPA, their application must be denied. If the court were to get to step two of UPEPA, Your Honor, the arguments that the defendant makes are also unavailing. First, they argue that the Board of Education has no standing. Of course it does, Your Honor. We cite at length, Your Honor, the Supreme Court's description of the doctrine of in loco parentis in Frugis versus Brasigliano, which is a 2003 New Jersey Supreme Court case. And I know it's in our brief, Your Honor, I'm gonna take the time to read it. While their children are educated during the day, parents transfer to school officials the power to act as the guardians of those young wards. No greater obligation is placed on school officials than to protect the children in their charge from foreseeable danger. That's why the New Brunswick Board of Education is here. That's why I was here on May 29th. That's why it continues to persist in seeking a preliminary injunction. The disclosure of that security footage, Your Honor, would place the students and the staff of the high school in danger, for the same reason that the Supreme Court indicated in Gillian that the public footage from the township town hall in Bloomfield should not be disclosed, Your Honor. So the board has an obligation, board has a duty, under not only the doctrine and local parentis, but under the statutes that we've cited, Your Honor, to maintain the confidentiality of these student records. That video footage is part of a disciplinary record of the student under the New Jersey Pupil Records Act. Under board policy, that footage is a student record. The board has an obligation, a legal obligation under both federal and state law to maintain its confidentiality. So in order to enforce that obligation, the board came to this court, a court of equity, seeking only an injunction, Your Honor, an injunction to protect so that it can enforce its own duties to the parents and enforce its own duties under the law to protect the confidentiality of that student record and to protect the security of all the students in the school, which would be put in jeopardy if video disclosure of the school security apparatus had been disclosed. It doesn't matter, Your Honor, as the defendant argues over and over again, that there's no private right of action under the New Jersey Pupils Act or under FERPA. We're not suing under FERPA or New Jersey Pupil Records Act. The Board of Education is seeking an injunction so that the confidentiality of the records under a duty imposed under it by the common law and by statutory law can be protected. That's it. It's not we're not seeking damages for disclosure of public records. What we're seeking, Your Honor, is an injunction to prevent the disclosure, which the federal government, the state of New Jersey, and the courts of the state have very, very long held are to be made confidential. To say it another way, they are not matters of public concern. Your Honor, in this regard, Your Honor, the expungement cases that the defendant relies upon really have no applicability. They discuss at length the Supreme Court's 2011 opinion in GD versus Kenny. There the Supreme Court said that the plaintiff, and this is an aside, who had had his criminal record expunged 13 years earlier, the plaintiff had no reasonable expectations of privacy, that information so long in the public domain before the entry of the expungement order would be erased from the public's mind or from papers already widely disseminated. That is completely different than the situation that's before the court today. That footage was disclosed for a brief period of time before the board could get to the court, and the court could enter expeditiously as it did to prevent further disclosure. But we're not talking about this campaign worker's now expunged criminal record, which had been public record for 13 years before it was expunged. We're talking about school security footage, which the school maintains as confidential under board policy, and which, because it is a student record, as a matter of law, is to be made confidential, and therefore is not a matter of public concern. The defendant's reliance on State's Newsroom versus Jersey City, Your Honor, we don't believe is on point at all. That case dealt with a request under the Expungement Act for an internal affairs report dealing with a law enforcement officer. All the Supreme Court decided in that case, Your Honor, was that the Expungement Act does not apply to an internal affairs report, and remanded and directed the trial court to do a balancing test as to whether the interests in favor of disclosure outweigh the concerns of confidentiality. In this case, Your Honor, if State Newsroom was applicable at all, if this court were to balance the concerns of disclosure against the concern for confidentiality, I may respectfully submit that confidentiality the scales of justice would very much tip in the favor of confidentiality. That's the reason why juvenile proceedings records are to be held confidential. That's why student disciplinary proceedings and student records are to be maintained confidential, because they are students, because they are minors, because if there is disclosure, there will be long-lasting and uncertain harm to that student in the long term, which cannot be predicted when that student is 16 years old. So the concern for confidentiality, Your Honor, is the concern of the reputational harm that would be done to that student if disclosure were permitted. The concern for the safety of the students at large within the school setting is paramount. And any disclosure of the security apparatus and the security procedures within the New Brunswick High School would likely put those students in jeopardy. So, Your Honor, the concern for confidentiality greatly exceeds the issue of disclosure. And not to mention, as I have mentioned already, Your Honor, that the defendant, we have not sought to have the defendant not be able to publish about this incident. It has. As I said before, other media outlets have. As I said before, the pleadings in this case have. Your Honor, in your preamble today, explained in general terms what occurred and what appears on that tape. That's enough. Identifying the student and jeopardizing student safety within that school, Your Honor, is not worth disclosure. I'm going to turn now, Your Honor, to the argument about whether Your Honor's court is a prior restraint. At first, I want to address Mr. Rosen's chastising me, I guess, for not citing the New York Times versus United States case, the Pentagon Papers case. Your Honor, I respectfully submit that that the defendant has it backwards. The public has a much greater interest in the government's self-analysis of how it conducted the Vietnam War than the public has in the identity of this 16-year-old student, or where the cameras are located within the New Brunswick High School, Your Honor. Given the concerns that are manifest in the statutes dealing with student records that we've discussed, given the concerns with student safety, which incidentally is why security footage is an exemption from the Oprah statute and Oprah disclosure, Your Honor, I think that the concern, the public concern for who this student actually is, what his name is, what he looks like, is just non-existent, Your Honor. As we said in our papers, Your Honor, a prior restraint is lawful. And now I'm referring to the CBS versus Davis case, Your Honor. A prior restraint is lawful where the evil that would result is both great and uncertain and cannot be mitigated by less intrusive means. I'm going to take the second part of that first, less intrusive means. As I said before, the defendant has published, has described what's on the tape. The court has described what's on the tape. The pleadings in this case describe what's on the tape. That's enough. What's the counterbalancing harm, Your Honor? Again, I've explained that already. What's the harm to this juvenile's reputation? Why do we maintain the confidentiality of student records, particularly disciplinary records? Why do we maintain the confidentiality of proceedings in the juvenile court? To protect the reputation, to protect from reputational harm against the student. This footage is a student record under the New Jersey Pupil Records Act and under FERPA. This footage is now part of the juvenile proceedings, criminal proceedings in the juvenile court for this student. There's a public expression that those records be maintained confidentially, Your Honor. Your Honor, also on the prior restraint argument, the defendant cites the case of Nebraska Press Association versus Stewart, which is a 1976 U.S. Supreme Court decision. Your Honor, again, in the Supreme Court in Nebraska Press, weighed whether there were less intrusive means than a restraint that the trial judge had imposed about pretrial disclosure until the jury was impaneled of the defendant's alleged statements prior to his arrest and confessions, Your Honor. The Supreme Court dissolved the injunction, but in doing so, It noted that the trial court had failed to consider a more limited injunction. The Supreme Court considered the fact that given all of the other pretrial publicity, that this injunction against disclosure of the defendant's confession was unlikely to have the benefit that the trial court had hoped when it imposed the injunction against the press. And the court also noticed that there had been live testimony in pretrial proceedings that disclosed the very information that the trial judge had tried to enjoin the press from publishing prior to the impaneling of the jury. In this case, Your Honor, the case before Your Honor, we have sought the least intrusive injunction we could possibly seek, so that as we can preserve the interests of this student and the interest of safety in the school. We've not, as I said, I'm repeating myself probably for the fourth time, they're free to report about it. They just can't show who this student was, they can't reveal his identity, and they can't show the footage that would disclose to a potential bad actor how the security apparatus at the high school operates and when it operates, and as the Supreme Court said in Gillian, how broadly the video takes, how narrow, if it's intermittent, all of that would be disclosed if this video was published by the defendant or any other media outlet, Your Honor. Judge, I do want to address that which was filed or submitted yesterday, a copy of the last text message that went out from the schools district regarding this incident. Whether the school district reported that there was a lockdown because there was a fire, or a lockdown because there was a gun, or a lockdown because there was a COVID outbreak, Your Honor, is immaterial to whether the identity of this student and the disclosure of the security apparatus of the high school is a matter of public concern. Neither are, Your Honor, and for that reason, the UPEPA order to show cause should be denied, the motion to dissolve the restraints should be denied, and the preliminary injunction which we sought in our order to show cause should be entered, Your Honor. Unless Your Honor has any questions, that's all I have to say.
I do have,
Okay.
two or three follow-ups, if you
Okay.
don't mind. First, when the matter came before the court on the initial application, it was only mid-hearing that the court was provided with a copy of a link of the video footage.
Okay.
That it took the opportunity to review before it concluded the hearing. The video depicts the subject, juvenile. There are also two other students in the video, coming in through the metal detectors. Isn't their identity in this instance qualifiable for protection against disclosure?
It
Don't
is,
they
Your Honor.
have privacy interests as well?
They do, Your Honor, and again, that's part of the board's obligations under the doctrine of in loco parentis to protect the safety of all of the students. And the identity of the students, Your Honor, we respectfully submit, is a student record under the New Jersey Pupil Records Act, which must be maintained in confidence.
The initial application included the attestation and certification of Dr. Aubrey Johnson, the superintendent of the schools.
Yes.
At that time, and without having it before me, my recollection was Dr. Johnson had indicated and certified that an investigation had been undertaken to discover how that video footage was released, because it's confidential and proprietary surveillance video footage of the school district. Has it ever been ascertained how it was obtained? Because in his certification, Mr. Kravitel asserts that it was lawfully obtained by him.
Judge, I do not know if it has ever been determined. It's my understanding that it has not yet been definitively determined how it was obtained. But I do want to, and I want to address Mr. Kravitel's allegation, the defense allegation that it was lawfully obtained. They've said it 4 or 5 times. without any explanation. Now, I understand that Mr. Bozeman's gonna argue that Mr. Cravatel has the right to protect his sources, whatever those sources may be. But other than saying it was lawfully obtained, that's all we have. No indication, not even the vaguest description of how it was lawfully obtained, Your Honor. So, we don't believe it was lawfully obtained, because those with access with it are prescribed by board policy from disclosing any of that footage because it is a student record.
And in that regard, given the defendant's opposition and arguments under the First Amendment and the rights of freedom of speech and freedom of expression, and in this case by a news organization, would the means by which that video footage was obtained, whether lawfully or unlawfully, be relevant?
Your Honor, for purposes of an analysis as to whether this is a prior restraint, I would say that it is not, Your Honor. This is not the same as the cases cited by the defendant where the court invited the press into the courtroom for a juvenile proceeding and then tried to prevent the court from disclosing the identity and the face of the student. That's not the same situation in the case where I believe it was in West Virginia, Your Honor, the West Virginia case, where the press learned the identity of the juvenile defendant by listening to police scanners and by eyewitnesses, and in fact, they were given the name of the juvenile, the accused juvenile, by an assistant prosecutor. That's not this case, Your Honor. Those who have possession and control of the security footage are prohibited by board policy and in fact by the law from disclosing it, Your Honor. So I think to the extent.
Well, let me stop you there.
Yeah.
Outside of this injunction proceeding, if it was determined that it was unlawfully obtained, that would result in separately actionable claims for damages by those who allege to have been harmed by it, or criminal prosecution.
I agree,
But
both are true.
there is the question raised by New Brunswick today about its exercise of its First Amendment rights of freedom of speech and freedom of expression and the publication of this, which was restrained, but that's why the question as to whether or not how New Brunswick today obtained it, lawfully or unlawfully, is it relevant to the court's fashioning or not fashioning a preliminary injunction?
Your Honor, I don't believe it is, Your Honor. Because of the protection that is afforded to these records by statute, it doesn't matter how they obtain it, whether they obtain it lawfully.
Okay, in fairness, and I just want to point out that to the parties and those who are here, this matter has been taken quite seriously by this court, and it's concerned on behalf of both sides because of the rights that are implicated. And on the one hand, the fact that a minor was apprehended at an entrance to a public school and determined to have a weapon on him raises a significant matter of concern of public interest. And there's the countervailing statutory requirements imposed to protect the privacy interests of those individuals that are depicted in that video. So that kind of defaults to my follow-up question, and that is, you addressed our case law that involves having the courts consider less intrusive means on the exercise of New Brunswick today's exercise of its constitutional rights of freedom of expression and speech. Would redactions of that video footage to blur or not have any markings of the individual such that the individual's identity can be determined, would would that be a fair balancing of both interests here, and allow the footage to be republished, as modified or blurred?
Your Honor, if the video was blurred in such a way that any identifying features, including clothing, was redacted, so to speak, that would take care of our first concern, Your Honor, with regard to the disclosure and the rights of this particular juvenile.
Yeah, hold the thought there. I don't mean to interrupt you, but, you know, as I obviously want to evince my concern of the interests of both sides here, it seems to the court that the cases do address as potential less intrusive means, something that has implicated, clearly something that was newsworthy and of the public interest and worthy of being reported, but at the same time, advancing and supporting the Board of Education's exercise of its statutory obligations to protect the privacy of what video now will become part of this student's educational records from disclosure. And that's why my question is if a blurring of the video would be something that would be doable, or as an alternative, wouldn't that satisfy the interest of both?
It might on our first concern, Your Honor, with regard to identifying the student and the other students in the video. It would not of our second concern, Your Honor, which would be a visual depiction of the security apparatus, the security procedures, the locations of the cameras, the very issue that the Supreme Court dealt with in Gillian versus Bloomfield.
Understood. Okay.
Okay?
All right.
Thank you, Your Honor.
Thank you very much, Mr. Mahoney. Mr. Rosen?
Thank you. First of all, let me apologize for interrupting you during your vacation. I didn't know it was your vacation, but I've been doing this for 35 years of First Amendment work, and the cases that we cited to the court, a loss of First Amendment rights, even for a few moments, are irreparable harm. That was our position. That's why we persevered. That's why we're zealous advocates. Certainly did not mean to interrupt your vacation.
Let me stop you there, Mr. Rosen, because first of all, no apology is necessary. Because at the outset, you may not recall that I recall that when we conducted the hearing, and I applaud you for it, you were in your car at the Maryland House in Maryland on the way to vacation.
No, on the way back from vacation.
On the way back. So I did accommodate the hearing by way of Zoom because of the time constraints going into the weekend and hearing that, but I respected that from the outset, as I do both sides here, and who are extremely well represented in this matter. But no need to apologize.
Thank you, Judge. Let me, it's a lot of cherry picking of cases here, but there's some basic principles. First of all, of course the board has duties under FERPA. It needs to go to the Secretary of Education to report on situations like this or protect it. Under the Pupil Records Act, it has certain requirements, and under local parentis it has certain requirements. None of those requirements, zero, impact what is in the possession of a reporter for presenting to the public something that's very important. Why is it important? We have an issue where a weapon was intercepted in a screening incident. There was a lockdown. There was a recovery of an airsoft gun. There was the detention of the student. This involves the conduct of public employees. This involves the very credibility of this board. The board was not credible. At first thing they did was they lied. They claimed that it was a routine drill to Mr. Cradaville, who stood up at a board meeting, asked the superintendent what happened during this lockdown. He said, oh, it was a toy gun. An airsoft it's not maybe not a lethal weapon, but it's a weapon under New Jersey statutes. It's a fourth degree crime under certain circumstances, and it's certainly a matter of public concern. Any way you look at this, it's a matter of public concern. You can cherry pick, well, this is a matter of public concern, but that's not a matter of public concern, but that's not how the law works. The publication of this was put up there to show that the board lied. The board lied first, the board lied second, and then they started walking it back to say, oh, well, we had communications problems, we had this or that. But it was important to show the people. Now, this stuff about, the identification or that's the board's problem, really. The board is the one who allowed a breach of their confidentiality. Mr. Cradle has no access to the security information, the security systems. Perhaps someone took a picture of it. Perhaps someone copied it. We don't know. But Mr. Cradle doesn't know, and it doesn't matter. There's a shield law that protects him from revealing any of this, and he can't be asked that by anyone. So, I'm sorry.
Well, let me stop you there, because he certifies to the court that he received it and it was lawfully obtained.
Okay.
How?
It does not matter how.
Well,
It-
no,
Judge-
that's my question.
Okay.
And if he wants to invoke the shield law, okay. But the point is, he opened the door to the question.
No,
He certified to
absolutely
the
not.
court, it is
Venezia,
lawfully obtained.
the Venezia case, the in re Venezia, which is a Supreme Court case that I was involved in 20-something years ago, the Supreme Court said that the waiver is only of what you present. You presented that it's lawfully obtained. That's it. That's actually, the reason why that's in there is because every one of those cases, those Daily Mail cases that we cited over and over again, starting from the Pentagon Papers, going through Cohn versus, Cox Broadcasting versus Cohn, Oklahoma Publishing, Smith versus the Daily Mail, Nebraska Press Association versus Stewart, to Bartnicki versus Vopper. All of those 7, 8 cases all together, and you can go back to Neer versus Minnesota when you're talking about prior restraints. In every one of them, the Supreme Court, although not declaring that there's an open classification, they said in every one of those cases, they determined that a lawfully received material, it's not stolen by the reporter. Pentagon Papers, stolen material from the Rand Corporation by Daniel Ellsberg, presented to the New York Times. It didn't matter that it was stolen. What matters was the New York Times didn't steal it. And the burden, because of the shield law and because of the First Amendment, is on the board to show that it was illegally obtained. But Mr. Mahoney says it doesn't matter. So if it doesn't matter, it doesn't matter. And I'm saying to the court, with great respect, and I'm sorry, I get a little worked up about this, that these are U.S. Supreme Court cases, one after the other, over a 20-year period. And every one of them said that lawfully obtained materials, cannot be restrained, and the only way that you could restrain them is to have a state interest of the highest order. And the examples presented of the highest order were national security, names of rape victims, publishing information about the identity of an 11-year-old boy charged with murder, another one with a juvenile defender. It doesn't matter the specifics of these cases, that this happened there and this happened there, because every case has the same exact message. The message is that when the news media gets something, they don't steal it themselves, you cannot restrain that. That's why I bothered you on reunification. I'm sorry. But
the courts also require a balancing of juvenile privacy against the public interest.
absolutely not, Your Honor.
Absolutely, yes.
I-
And in the case that your office and your partner argued, digital media, involved the recommendation and the support of redactions as opposed to censorship in order to achieve a balancing of privacy interests of juveniles.
If you go through all of these cases, there's names of rape victims, there's names of 11-year-old boys who were accused of committing murders. All of these cases, there's no restraint whatsoever. There's no editing of this. And the other thing, Judge, that's very important, is that this was out there. At least 5,400 people saw this. 5,400 people saw everything that went on. And it's not a secret. This is out there. And of course, Mr. Cradaville took this down within minutes of that hearing after I spoke to him from the Maryland House. But it's out there. People saw this, it's done. This
Which
is
the court acknowledged, and which underscored its need to stop it pending the return date and the briefing on the implicated constitutional issues and the state statute and federal statutory requirements imposed upon the Board of Ed to safeguard from disclosure confidential or private records of a juvenile, educational records of a juvenile.
Judge, with respect, that's their duty. That's their responsibility.
Which is why they brought the action
But it has nothing to do
to
with
restrain it.
But it has nothing at all to do with the rights of a reporter under the First Amendment. Nothing. And the First Amendment comes before any statutory obligation. Yes, the First Amendment comes before the statutory obligation.
With exceptions.
There may be exceptions. I couldn't think of one at this particular moment.
Interested juveniles.
No, Your Honor, that's
FERPA.
no, Your Honor, no. That's with respect. That's not the case. FERPA
New Jersey law, the New Jersey Pupil Records Act,
There's
the
no.
New Jersey Juvenile Records Act,
But that's
the
the
district policies and regulations that were promulgated in furtherance of those to ensure against the disclosure of confidential juvenile educational records without their consent or their parents' consent.
That is the board's responsibility to
Which
do
is
that.
what it exercised in filing this action to stop it, at least up front, to preserve as a equitable policing mechanism the status quo at that point in time and to stop its publication pending this hearing.
With respect.
Didn't have to have a private cause of action to seek injunctive relief.
With respect, Your Honor, the cases are very clear that you need a state interest of the highest magnitude. This is not a state interest of the highest magnitude. The cases are very clear. This applies to rape victims' names, juveniles in several cases, and national security information like the Pentagon Papers. That comes before the identity of a 16-year-old on a blurry black and white video that we don't know who that is and why that was, and the name's not even important. What's important is that the board made certain representations. New Brunswick today pointed out that the representations were wrong and the board lacked credibility in what it was saying to the public. It's a matter of public concern. And not for nothing, but I don't want me to switch back and forth, but UPEPA allows for even part of an action to proceed, not just, you don't have to win totally. And that's Milton versus CNBC, which was just decided by the appellate division. But look, may I sort of back up and?
Yeah, please,
Okay,
please.
thank you.
And forgive me if I'm interrupting you.
Oh, no.
And I
It's-
want to hear you. Why do we have argument?
I'm happy to argue with you, Judge. So, this is a prior restraint. We pointed out in our papers, the Bantam Books versus Sullivan case, that, the court ruled that you cannot publish this any longer and you need to take this down. And you can't also publish these other things about any security apparatus of the school district. And then when I asked the question to Your Honor about, because I did not want my client to be in any sort of trouble, can he write about this? Your Honor extended the prohibition and made it even broader than the school district asked for. It's a
Which, by the way, I'm interrupting you.
Please.
I will candidly acknowledge that after reviewing the papers and getting to this hearing, to perform what the appellate division acknowledged itself was to have a constitutional analysis performed by me in the first instance. It may very well be that the third restraint that I imposed was overbroad and worthy of modification, if not elimination. So I'll give you that.
I'll take your crumbs, Judge.
But I see, I'm doing this a long time, then in each of your shoes, I'm on this side now. It's always a welcome pleasure for this court to hear from zealous advocates. And it's hard at times for the court to make a decision, but it's being called upon to make a decision, which is why we have the procedures that we do. My entered orders here, I've invited to have the briefing done and had the benefit of it. And I'm focusing my questions on things that I need to have answered for me to satisfy myself as I think through ultimately what the decision would be in this case. But I need it to be understood by the public here. I have not lost sight on the public interest implicated by this incident. Nor have I lost sight on being a parent, the fact that there is a minor and a juvenile who is implicated here and others who are identified. And it is somewhat of a struggle to ensure that the right decision is distilled after balancing the interests and applying the law as it has evolved, both at the federal level and the state level. That's all.
Judge, I appreciate that, and as a parent, grandparent, I appreciate that too. On the other hand, having been a First Amendment advocate for many, many years, and having been a newspaper reporter before that, and an editor, I am very confident, and I think our briefs are just as confident, that cases, just as an example, Oklahoma Publishing Company versus District Court struck down an order prohibiting the press from publishing information obtained in a preliminary hearing about an 11-year-old boy charged with murder. And first of all, it was out there already because it was at a public hearing. But second of all, it involved that 11-year-old. Now, no one is saying, like the court was implying earlier, well, I wanted to stop from getting more out there. 5,400 people know about this, saw this. It's out there. They have the right to they see it. Maybe some people downloaded that video for all we know. We have no idea. But these cases are First Amendment cases. A First Amendment, whenever there's no balancing per se. You either get to the need for to further a state interest of the highest order, or you don't. That is simply the only balancing test that's involved here. And every one of those cases say that a reporter that receives information, even if it is confidential, it has a First Amendment right to publish. Every one of those cases. Now, what the board says is, we have this logo parentis. We're responsible for this. Of course they're responsible for this. I want the board to be responsible for it. But the board has been irresponsible for it because they are the ones that somehow allowed someone within their purview to get this thing out there. That's their problem. That's not the press's problem. The press got what somehow landed on New Brunswick Today's desk. It contradicted what the superintendent said at a public meeting and what whoever sent out that text that was put into the record yesterday. There's no real statute here that says that someone outside the board who has this information cannot publish it. What you have is you have certain federal regulations under FERPA. You have certain state regulations under the Pupil Act. You can't get the information from law enforcement. You can't get the information from the courts or probation. Right, those are the rules, you can't do that. It's the same with the Expungement Act that was being disparaged before. In GD versus Kenny, that same law was out there. It was a disorderly person's $50 fine if you reveal an expungement. That's the same thing that's in this act. There's a fine or a penalty if you reveal something under the Pupil Records Act. But what the court said is it doesn't apply to outsiders. It's really like a check on employees or those with access. It has nothing to do with outside. These cases are clear that this First Amendment right is there. This is not, Judge, you're a court of equity. Every day you sit here and you got the scales of justice. You go up and down and you try to even it out and you figure out. But this is not that. This is the First Amendment. This is up and everything else is down. And that's the way it has been since 1964 or 1931 with Neer versus Minnesota, 1964 with New York Times versus Sullivan, and then all of these Daily Mail cases starting in 1979 or 1970 with the Pentagon Papers.
71.
71, excuse me.
Robert McNamara.
Robert McNamara. It's a good movie. Anyway, these obviously UPEPA and our arguments on restraints overlap. So they're almost one and the same, and it was clear from counsel's argument before that they do. So, matter of public concern, already gone over that. The safety and security of the school, the Rossi case, teachers or things involving teachers, matters of public concern. In addition, UPEPA says that a communication involving a matter under consideration in a court is also automatically a matter of public concern, and as pointed out, with this sort of cockamamie thing about this being evidence and you can't report on evidence, it's a communication involving a juvenile proceeding. So it's clearly, it's a proceeding. It doesn't say that it doesn't apply to juvenile proceedings. It says it applies to proceedings, judicial proceedings. That's what this is about. If someone was just writing about a juvenile without their name and saying, this 15-year-old started, is responsible for a murder and the community's in an uproar, you certainly you'd agree that was a matter of public concern. And here, the only reason why they're saying it's not is because, for two reasons, is that it identifies someone and it supposedly shows the security, which is another ludicrous argument, because everyone walking through that building sees the security. Every one of those 5,400 people who watched it saw the security. It's a standard security. They haven't provided any specific information about how it has been compromised. And guess what? They could change the location of the cameras. This is not something that is like a super secret. Everyone knows how many security people they have at these gates. It's just not. It's just not something that is a matter of the highest order. That state interest is the highest order. So, the incident, the plaintiff acknowledges the incident may be news. What they say is the identity of the minor student is not. We don't parse like that. The whole thing is news. Everything about that is news. It's news that somebody brought this in. The fact that they were identified in the process is irrelevant. To the media, not irrelevant to them, not at all. They had a responsibility to do something. They didn't do it. They didn't.
Suit.
I'm sorry?
They filed suit.
No, but they had a responsibility.
Take it down.
They had a responsibility before that to protect their information and to take care of it and make sure that it didn't get out to the public.
And it was invaded.
Why?
And published.
Well,
And they filed the action to restrain it, pending this discussion and
someone accessed materials and provided it to the media. It wasn't the media that went out in and took this material.
A minor who was detected as having an airsoft BB gun on him concern of an imminent threat of safety for students accessing the building at that location, and/or provoking, perhaps in theory, a disgruntled student who may want to do the same thing but knows not to go to that location.
So then you have to matter of public concern, Judge. It's as clear as that. It's a matter of public
So
concern.
how does UPA, and by the way, we keep referring to UPEPA as convenient acronym, and I will too, but it stands for the Uniform Public Expression Protection Act, UPEPA.
That's right.
How does UPEPA even apply here?
Because an action was brought to stop speech. That's how it was applied here. And it applies in two circumstances.
And therefore, the Brunswick Board of Education as a governmental unit was explicitly exempt from UPEPA.
Not at all.
Really?
Really.
Well, you just alluded to and cited to UPEPA and looking at 2A:53A50, at subsection B. Quote, except as otherwise provided in subsection C, this act applies to a cause of action asserted in a civil action against the person based on the person's, 1, communication in a legislative, executive, judicial, administrative, or other governmental proceeding. 2, communication on an issue under consideration or review in a legislative, executive, judicial, administrative, or other governmental proceeding. Or 3, exercise of the right of freedom of speech or of the press, the right to assembly or petition, or the right of association guaranteed by the United States Constitution or New Jersey Constitution on a matter of public concern.
I'd say we fit into all three of them.
But you didn't read subsection C.
I did read those subsections.
This act does not apply to a cause of action, subsection 2, quote, by a governmental unit or an employee or an agent of a governmental unit acting in an official capacity to enforce a law to protect against an imminent threat to public health or safety, which is precisely what the Board of Ed did in filing the action.
Well, I
So
disagree.
UPEPA is not even applicable.
Okay, well, that's why it provides for an interlocutory appeal as of right. And we'll deal with it there, Judge, with all due respect. But
Well, I'm just asking you,
and
in the briefing, it was just the exception in the statute you relied upon, and you cited to and quoted, provides, except as otherwise provided in subsection C. And subsection C applies to the New Brunswick Board of Education. It's exempt, doesn't apply to it.
Well, I don't believe this is a matter of public safety. This is a public safety. This is.
Sure it was. You've argued it, the other side of your mouth, I'm sorry, that the fact that it was of newsworthiness and would implicate the public safety without it being disclosed publicly that a student was apprehended at the entrance to New Brunswick High School with a weapon. Which is it?
I would disagree that this is fits into that exception. And this was brought to silence. They might think that this is their duty or their responsibility or that it's under these various statutes, but it does not apply because of the First Amendment. There's a First Amendment right to provide this material and to have this material, to republish this material, and I don't believe that it applies. Even if it does apply, Judge, the most important thing here are the restraints, there's no balancing test here. This is not a court of equity in that sense. The First Amendment takes precedence over these statutes. Every one of those cases that I cited to you, a statute was struck down. Every one of them, or overridden. Every single one of them. Every one involving juveniles, involving the names of rape victims. Every one of them, because the First Amendment took precedence. The board's duties and policies are the board's duties and policies. They're not the media's duties and policies. The media has a different job. The different job is to point out things that are matters of public concern. This was certainly a matter of public concern. Whether it means that UPEPA doesn't apply or not, we can argue that at another time. But it's clear that the board's duties and policies are the board's issue, and the board needs to follow those things. That their argument that New Brunswick Today should have done more, blurred faces, they have a bad motivation, speculative, and making stuff up out of whole cloth. They have no authority over what New Brunswick Today does. Zero. And they cannot just say, well, you could say this, but you can't say that. You could do this, but you can't do that. They have their own duties and obligations. Yes, they sued, but they sued under a false pretense, and the false pretense is that their own duties and responsibilities are superior to the First Amendment. That's the false pretense here, Judge. And again, the local parentis describes the board's duty, not New Brunswick Today's. That fact that it may be confidential, it means nothing in the sense of the First Amendment, because reporters are getting confidential information constantly. This is like, since the beginning of reporterdom, people get things that they're not supposed to have. And it doesn't really matter. And school security, they have the responsibility to make a concrete showing that there was a security, that this really affected their security. And they can't deny that the security is witnessed by students, faculty, everyone, every day, and those 5,400 people saw what was going on there. And they really don't explain why they couldn't make their own changes, remedial changes to fix whatever they thought was revealed by that document. Unless the court has any further questions, I think we're I guess, a little bit of a loggerhead.
I wouldn't consider it loggerhead. This is why we have argument.
Judge, if I may.
Thank you.
I'm going to be very brief, Your Honor. Mr. Rosen started his argument by saying that the video was published to show that the board lied. I don't know if the board lied or not, Your Honor. But he then spent the next half hour never explaining why the identity of this student or a visual depiction of the security apparatus in this high school is material to the issue as to whether the board lied or not, Your Honor. At 2:33, I looked at the clock and I wrote it down. He said the name, meaning of the student, isn't even important. If it isn't, Your Honor, then there should be no publication of this video. Thank you, Your Honor.
The text message that the court received a copy of in the supplemental certification yesterday, whether the board lied or not is not known. But there's also conceivably the manner in which it was determined to send that out without inciting unnecessarily any further issues until an investigation had been completed. And who knows? I'm just spitballing, but that has no relevance here, but at least as far as I'm concerned. But discussions had at the board level at meetings are coverable by the press.
And the video
report that, but here we've thrown into the mix video footage that's been described, which implicates a whole array of other statutory obligations the board had, that it was through this action attempting to enforce, subject to whatever the court's determination would be.
Thank you, I have nothing further.
Yeah.
The only thing I would add, Judge, is that Gillard case is an Oprah case. It has nothing to do with the issues that we're discussing here today, except there was one point in the brief, which, by the way, was argued by C.J. Griffin.
Well, did you read it? It was an Oprah case. Yeah, but it bears noting, since Mr. Griffin was involved in the briefing in this case, he did argue that case, and the court's familiar with that case, and in that case, the appellate division itself wrote, even though it was an Oprah case, there was a similar circumstance here about disclosure of a juvenile's identity and the like, and.
But there was there's no First Amendment
Well,
assertions there.
Well, with respect to the legislative history of the statute, the juvenile record statute that Mr. Mahoney relies upon here, among others, as this, the authority under which it undertook to take the action it did here to safeguard the privacy interest of this. The Appellate Division in Digital First Media, and I'm quoting, held towards the end of its decision, the legislative history of NJSA 2A:4A-60, which is the statute, and the governor's statement issued when the statute was enacted, both indicate that the provisions regarding confidentiality were intended to balance the public's right to be informed against the rehabilitation of the juvenile, a balance readily accomplished here by a redaction of the juvenile's name, and cites to the Senate committee statement and the governor's conditional veto message. And they continued, nor does a juvenile UFR, which in that case was a use of force report that was sought under Oprah, fall within the exceptions to availability of government records deemed confidential, enumerated within Oprah itself. The simple redaction of the subject's name accomplishes the goal of both statutes, which is really what I was getting at in my question to Mr. Mahoney.
I understand that, Judge.
There was a blurring or redaction of the video, wouldn't that balance both interests?
Again, Judge, this is an Oprah case. It's a case about obtaining records from.
Digital media.
Right, about a.
462 NJ Super 389, television in 2020.
It was a case about obtaining records from the government. And the issue there is, are the records obtainable under Oprah, the common law? And they're balancing that Oprah request against the statute. There's balancing.
Well, this
at least
video
in the-
becomes an education record of this pupil depicted in the video footage. How is that any different? By way
Because,
of analogy in balancing the respective interests.
because you have a First Amendment interest here that's being asserted. That case did not involve the First Amendment, did not involve 6, 7, 8 Supreme Court cases that say that the First Amendment takes precedence over these statutes. And in fact, these statutes were struck down. And I'm not asking to strike down any statutes. I'm saying that the statutes are inapplicable because they don't reach a state interest of the highest, a state interest of the highest order.
But the relief that you sought in your order to show cause under UPEPA, by its very exception, insulates and exempts the Board of Education from its application.
Judge, if that's the case,
That's the statute,
Okay.
which I read. It couldn't be any clearer.
Okay, if the court's going to rule that way.
No, I'm just stating, that's why
Okay.
the question to you.
That doesn't go to the restraints, and that's the main reason we're here. If we could get, UPEPA at the same time, that would be terrific, but we're here about the restraints. We're here about a First Amendment issue. We're here not about a balancing test. This is not a balancing test. You either have a state interest of the highest order, or you don't. And this is not a state interest of the highest order under numerous U.S. Supreme Court cases. And that Gilman case has nothing to do with the issues that are out here today. Thank you.
Anything further?
Not from this side, Your Honor, thank you.
All right, obviously, I lost track of time. But I do genuinely applaud and appreciate the effort made on both sides here in the argument. I need to think about the responses and the issues that have come up in my own mind from the argument. I'm going to reserve decision, but I'll issue a decision within a day or two if I can. Other unknown emergencies that come before this court every day that may detain me from it, but I want to act as quickly as I intended to from day one.
Thank you.
Okay.
Thank you, Your
All
Honor.
right. Thank you all, and all who are here, please, all of you, be happy, well, and safe. That's in order. Hopefully you can live with that, but thank you.
Thank you, Your Honor.